The real estate purchase and sale agreement, also called the real estate contract, is the backbone of every real estate transaction. The terms of the real estate contract are numerous and often complicated. Understanding each section of the real estate contract, the standards for negotiation, and the rights and responsibilities of each party is an essential skill for every real estate professional. In order to have a contract for real estate, all we need are parties who are legally competent, a written document identifying the real estate to be sold, for how much money, when, and the parties' signatures. Indeed, a real estate deal could be written on a cocktail napkin. But what happens when something goes wrong? What happens when the parties are unsure about a material detail of the agreement? Will there be a deposit? Who holds it? What happens if a party backs out? What happens if the buyer backs out because he can't get a loan? Does the seller really own the property? What about liens, easements, and claims others may have to the real estate? Will the seller protect the buyer if there is a question about his ownership down the line? That's why in the United States it is common to use a longer, more complicated real estate contract. Every section of the real estate contract is there because there have been numerous lawsuits about that specific term. And the term was added to standard real estate contracts to avoid lawsuits down the road. Let's first break down the sections of a standard real estate contract. The introduction will have the names of the parties. The buyer and seller are identified. In standard residential real estate contracts, this will just be their names. There can be more than one buyer or seller. For the seller, all owners of record must be listed. Usually for married couples, both spouses will be listed. If one of the parties is a corporation, partnership, or other entity, the entity will be listed, along with their state of incorporation or organization. If an entity is a party, a human being has to sign on behalf of the entity, in their capacity as a duly authorized representative. This will be at the end in the signature block. At the beginning, you will often see the date of the contract. This is very important. Many of the terms of the contract relate back to the date the contract was signed. As we'll discuss later on, the buyer may have 30 days to inspect the property from the date of the contract. Or the closing must take place within 60 days of the date of the contract. Often, with residential real estate contracts, a proposed contract is the offer made by the buyer to the seller, and the offer is valid from a certain number of days from the date of the contract. The contract date is also important in determining priority of offers. If multiple offers come in, or multiple contracts are signed at the same time, the contract signed first is usually valid, while the later contracts may be invalid because the parties have already entered into a commitment. Next in the real estate contract is identification of the property. At this point in the contract, the property is usually described by its address. The address should include the country, city, and state. Attached to the real estate contract, as an exhibit, is the legal description of the property. The legal description is the technical description of the boundaries and location of the real estate. The purchase price usually appears next in the real estate contract. The purchase price clause includes the method of payment. Will the buyer pay with cash, a mortgage loan, or a combination? The clause will describe what percentage of the purchase price will be a down payment and what percentage will be financed through a lender. Often, this clause contains a contingency that the contract will be voided if the buyer is unable to get a mortgage at certain terms. The terms usually include a ceiling interest rate and maximum down payment. The purpose of this clause is to make the contract feasible. The buyer knows, or should know, how much he can afford to pay each month. If a bank will not offer terms to make the payment feasible, then the buyer should not be forced to follow through with the contract. Along with the purchase price, the real estate contract will state whether any earnest money has been paid by the buyer and who is serving as the escrow agent for the earnest money. The earnest money serves as a commitment by the buyer to complete the closing and to not back out of the contract with good cause. Along with the description of the earnest money, there are stated terms and conditions of what happens to the earnest money when the closing succeeds or if the contract is voided. The real estate contract will list the closing date. The date is usually an endpoint, meaning that the closing will not take place after a certain date. The date is usually flexible, and the contract will allow the parties to mutually agree to change the closing date. With the closing date, the contract usually lists the closing attorney or closing agent. Local custom dictates who selects the closing attorney. It may be the mortgage lender, the buyer, or whichever party is paying closing costs. The next section of the contract gets more legalistic. There is a recitation of the seller's ownership interest and how the owner will provide evidence of ownership. This section will describe how and what title are legally conveyed to the buyer when the closing takes place. This is where the warranties are made. We'll discuss warranties in a bit. Next comes the issue of proration. When the buyer takes title to the property, he will immediately become responsible for real estate taxes, utilities, homeowner association dues, and all expenses of the property. Odds are the closing will take place in the middle of the month. The seller may have paid some of these expenses in advance and is entitled to the prorated or a portion of the expenses to be reimbursed. In other words, if the seller paid $100 for the trash pickup in advance for the full month, and the closing takes place on the 15th of the month, then the buyer has to pay the seller back $50 for the portion of the month that the buyer owns the property. In many states and counties, real estate taxes are paid annually, so the calculation has to be done to calculate how many days of the year have been paid for and how many days have to be reimbursed. The opposite is true as well. If bills are paid at the end of the month, like the electric bill, then the seller will have to reimburse the buyer after closing. In this scenario, money is usually held by the closing attorney in escrow, based on estimated bills from past months. Sometimes the service provider or utility will give you a total due as of the date of the closing, and estimations won't be necessary. Proration is done by dividing the bill by the number of days in the month or year, depending on how often the bill is paid, and counting the days before the closing as the seller's responsibility, and the days after the closing as the buyer's responsibility. The contract then moves on to talk about default. Default is when one of the parties fails to fulfill the terms of the contract. In the context of a real estate contract, default usually means failing to close. The default section describes the different types of default, the reasons for default, and the remedies available to each party in the event that the other defaults. Common situations of default include the buyers simply refusing to buy, the seller refusing to sell, the buyer being unable to get financing, or some other glitch in the due diligence process. Each has its own remedy. When the buyer simply refuses to close without good cause, then the usual remedy is for the earnest money to be turned over to the seller as a penalty. The seller usually does not have the right to sue the buyer to force closing. Courts are generally unwilling to force a closing on an unwilling buyer. He may refuse to buy because he doesn't have the money. Turning over the earnest money is called liquidated damages. It is the amount of money that the seller estimates he lost by entering into the contract, and the damages sustained by the buyer's default. In order to collect liquidated damages, the earnest money clause and the default clause have to be written with specific language, with each state having its own law as to the required language. When the seller defaults and refuses to sell, the buyer will get the earnest money back. But, depending on the terms of the contract, the buyer may be able to sue the seller to force a closing. The buyer may also be able to sue for lost profits or other benefit that the building would have provided him, or other damages if the buyer has to buy a more expensive property. Since the opportunities for lawsuit are numerous, contracts often limit the buyer's remedy to collecting the earnest money. If the buyer defaults because he could not obtain the financing required by the contract, then usually the earnest money goes back to the buyer. If the buyer refuses to close because during the inspection of the property or inspection of the title, something turned up that would make closing impossible, or things are contrary to the warranties made by the seller, then the earnest money goes back to the buyer. Another event of default is usually insolvency or bankruptcy. If one of the parties goes into bankruptcy, then the contract is usually voided. Bankruptcy law will not allow a buyer in bankruptcy to complete the transaction. If the seller is in bankruptcy, the real estate becomes the property of the bankruptcy trustee. The trustee may allow the closing to go forward, but isn't under any obligation to do so. Along with the events of default are the contingency clauses. A contingency clause states a requirement for the closing to happen, or an event that could cancel the closing. A contingency clause says, the closing will take place if this happens, or the closing will not take place if this happens. The most common contingency clause is referred to as the mortgage contingency. As we said earlier, the mortgage contingency goes back to the purchase price. If the buyer is financing a part of the purchase price, he has an opportunity to obtain a mortgage loan under terms that are feasible, meaning an interest rate, term, and down payment of certain amounts. If the buyer, after diligent effort, is unable to obtain a loan that falls within the contingency, the contract can be canceled without penalty. Another common contingency is inspection. the buyer is given an amount of time to go on to the property and physically inspect it. Often, the buyer brings in an engineer or contractor to make sure the building is structurally sound and to identify any defects that the untrained eye might miss. If the property does not satisfy the inspector's standards of a structure that does not require extensive renovation, then the contract may be canceled. A home sale contingency is for the buyer's benefit. It allows the buyer time to sell his old home first so that he can afford to buy the new home. Often, the buyer is able to schedule the two closings consecutively, first selling his old home, then using the sale proceeds to buy the new home. However, if the buyer is unable to sell his old home within a given time, this contingency clause allows the buyer to cancel the contract. Another contingency is the insurance contingency. In this clause, the buyer is given an opportunity to obtain property insurance covering the real estate. This is rarely a problem. But if, for some reason, the buyer is unable to obtain insurance, the contract can be canceled. The insurance contingency has another extension, namely title insurance. As part of the closing and inspection, the buyer will review the title history of the subject real estate. If the seller is unable to deliver clear title, it is likely that the buyer will be unable to obtain title insurance. In that case, the insurance contingency will allow the contract to be canceled. In addition to contingencies, the seller will make certain warranties to the buyer. Warranties are essentially promises or guarantees. Common warranties are that the seller is the owner of the property, that the seller can transfer clear title to the buyer, that all the easements and liens of record are the only liens and easements on the property, and that the seller is able to sell the property and the property is fit for its intended use. Most real estate contracts contain additional provisions, and these will be crafted by the drafter based on the particular transaction. It's a good idea to list and describe all personal property left behind in the property for the buyer. Personal property and real property are governed by different sets of rules. One of the biggest sources of confusion after a closing is personal property. First, defining personal property is difficult. The buyer will take a narrow definition, including everything possible as part of the real estate. However, the seller will take a broad view, thinking that personal property is not part of the real estate and was not included in the contract. Furniture is an easy example. Most people would not consider a bed or sofa part of the real estate. So if those were being included in the real estate sale, they would be listed in the additional provisions. But appliances are a different story, as are light fixtures, wall units, and bathroom fixtures. The seller may want to take those with him, and they can be removed without much damage to the house itself. But the buyer may expect those to be included because they're seemingly built into the house. In a dispute in court, the analysis can get very deep. For our purposes here, the lesson is to include as much detail as possible about personal property. What is going to stay with the real estate and what is not. If personal property remains with the real estate, especially air conditioning units, appliances, or electronics, which might still be under warranty, then the transfer of those warranties should be noted in this section. The appointment of the closing attorney or title agent can be listed in a number of different places. Some contracts add the appointment in a separate provision rather than mixing it with the closing date. This depends on local custom. While the buyer will have an inspection period to formally evaluate the condition of the real estate, there is often an additional provision to the real estate contract that allows the buyer to walk through the property one last time before the closing. The purpose of this provision is to allow the buyer to make sure that nothing has materially changed about the real estate since the inspection. A material change could be grounds to cancel the contract or postpone the closing. A material change could include fire or storm damage, major alteration to the building on the land, willful damage to the property, or anything that would render a warranty made earlier in the contract invalid. The contract ends with the signatures of each party. If one of the parties is a corporation or other non-human entity, the real estate contract is signed by a duly appointed representative who will affix the corporate seal of the entity. Sometimes a resolution of the corporation, partnership, or other entity is attached to the real estate contract, showing the signer's authority to bind the entity. But that's not really the end. Most real estate contracts have addenda, or pages added on to the end of the contract. Since real estate contracts in many states are pre-printed forms, the addendum is the place to put specific closing information and other documents. But be careful. In order for the addenda to be considered part of the real estate contract, they have to be referenced somewhere in the real estate contract itself and made a part of the contract by reference. The most common addendum is the legal description of the subject real estate. The contract itself usually has the address of the property, but the address is not specific enough to craft a deed or perform a title search. The legal description has the metes and bounds describing the borders of the real estate. It's possible that the seller is only selling part of his real estate. That would make the address meaningless. The legal description reflects the property that is subject of the sale. In a typical transaction, the legal description is copied from the seller's deed that he received when he bought the property and is copied over again to the deed given to the buyer. Another common addendum is the description of the personal property being transferred as part of the sale. Again, this can be inside the contract, but since most real estate contracts are standard forms, there may not be space for an exhaustive list. Sometimes a real estate contract will have an escrow agreement addendum. Some states favor having more details written out for the person holding the earnest money deposit, describing how to dispose of the money. Also, many escrow agents want a separate document signed by both parties releasing the escrow agent from liability in the event of a dispute. In commercial real estate contracts, it is common to have an addendum that lists the known easements, restrictions, and liens of record, so the buyer knows exactly what they're getting into. Other attachments to a real estate contract are called amendments. An amendment is a change to a term in the existing real estate contract. For example, one common amendment is the changing of the closing date. That usually happens because banks take longer to approve loans and the closing has to be moved to a later date. Sometimes the closing is moved up when things go smoothly. Sometimes life events just come up and the day has to be changed. In commercial real estate transactions, there is typically an amendment changing the name of the buyer. Many commercial properties are purchased by single-purpose limited liability companies. So, while the contract was signed and negotiated by one company, that company will open a separate limited liability company to hold title to the real estate. This is common for tax and liability purposes. Amendments and addenda are different, although they might sound similar. An addendum provides supplemental information regarding the real estate contract. An amendment actually changes a term of the real estate contract. An amendment must be signed by both parties, just like the real estate contract, while an amendment is part of the contract and does not need a separate signature.